Hi, I'm Emily, and I am here with Maya Murphy's attorney, Lauren MacDonald. Attorney MacDonald practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My question today for Attorney MacDonald is, what is the law in Connecticut regarding teacher performance evaluations?
Hi, Emily. Thank you for the question. So each year, teachers in Connecticut must be evaluated by either the superintendent of schools or by someone appointed by the superintendent. The teacher's evaluations shall include, but is not necessarily limited to, strengths, areas needing improvement, strategies for improvement, and multiple indicators of student academic growth. In the event that a teacher does not receive a summative evaluation during the school year, the teacher must receive a not rated designation for that school year. The superintendent shall report both the status of teacher evaluations to the local or regional Board of Education on or before June 1st of each school year, and the status of the implementation of the teacher evaluation and support program, including the frequency of evaluations, aggregate evaluation ratings, and number of teachers who have not been evaluated, and other requirements as determined by the Department of Education to the Commissioner of Education on or before September 15th of each year. If a teacher believes that the proper procedure was not followed during their review and/or evaluation, the teacher should look to the collective bargaining agreement maintained within the school district, as Connecticut defers to such agreements for grievance procedures on such evaluations. Each local and regional Board of Education must adopt and implement a teacher evaluation and support program. If a local or regional Board of Education is unable to develop a teacher evaluation and support program through mutual agreement with a professional development and evaluation committee, then the Board of Education and the Professional Development and Evaluation Committee shall consider the model teacher evaluation and support program adopted by the State Board of Education as a rubric and can adopt the model if agreed upon. After a teacher has received their performance evaluation, Connecticut law ensures confidentiality from the public. Any records maintained or kept on file by the Department of Education or any local or regional Board of Education that are records of teacher performance and evaluation shall not be deemed to be public records, provided that any teacher may consent in writing to the release of such teachers' records by the department or a Board of Education. However, Connecticut does provide certain exceptions to the confidentiality rule, providing that records maintained or kept under file by the Department of Education or any local or regional Board of Education that are records of the personal misconduct of a teacher shall be deemed to be public records and shall be subject to disclosure in certain circumstances. Further, disclosure of such records of a teacher's personal misconduct shall not require the consent of the teacher. Despite confidentiality, the teacher is allowed access to his or her personnel file and its contents under Connecticut law. The teacher shall be entitled to knowledge of, access to, and upon request, a copy of supervisory records and reports of competence, personal character, and efficiency maintained in their personnel file with reference to evaluation of performance. If a teacher would like to investigate the contents of their personnel file, that is their right under Connecticut law, but must make a request to the Board of Education of the town in which he or she is employed. If you have any questions regarding your teacher evaluation in Connecticut, please feel free to give me a call.
Attorney MacDonald is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney MacDonald at LMacdonald@mayalaw.com, and please visit mayalaw.com for more information.